For this conference, we have done a largest survey on the sexual harassment, and plus we have published one book that has the law relating to sexual harassment as well as result of our sexual harassment survey. Uh, it's for the first time that any survey is done online as well as on the site, and I must appreciate our student section to do a very good job for this survey. So as usual, for our following Indian traditions, let us light a lamp. I would like to invite Mr. Sarosh Zaiwalla to come forward, and Shri Suresh Chandra ji, Union Law Secretary, and Sanjay, please come and let us light the lamp. Andrea as well, come. As per the Indian tradition, we start. She is a legal head and the from the Ministry of Finance of Slovakia.
Maybe have a round of applause, please. Good morning, ladies and gentlemen, once again, and welcome to the 67th Constitution Day. A remarkable day in Indian democracy, and we are now celebrating its 67th year. And I'll just like to invite on stage Honorable Law Secretary Shri Suresh Chandra ji, Mr. Sarosh Zaiwalla, Senior Partner from Zaiwalla and Company UK, Mr. Kaviraj Singh, Secretary, Indian National Bar Association. Before we start, if I have the permission from the Honorable Law Secretary, I just thought it will be appropriate to possibly read the pledge. If you may permit me, sir. So I have the pledge with me. So if I have your kind permission, I'll read the pledge. The Constitution of India's preamble, which talks about we the people of India, having solemnly resolved to constitute India into a sovereign socialist, secular democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So as a proud nation, we are very happy that we continue to live with this legacy. I believe the largest piece of legislation in the world. With that, over to you.
First of all, thank you, the conference organizer, for inviting me to speak, and I'm honored to sit next to Mr. Suresh Chandra, and I had a meeting with him yesterday, and I can say that he's genuinely a straight and a sincere man with a fear of God, and India is proud to have him. And I hope that with that, India will change, and the Indian judiciary will change, and legal jurisprudence will stand. I'll just introduce myself. We are the first law firm in the city of London, started by somebody who was born in Asia. And today in the English law report, there are 104 reported cases where my firm has acted for one of the parties. And we today act for more non-Indian clients and Indian clients. Just for an example, we act for Russian Federation. We acted in the UCOS case as a consultant. We are just now pursuing a claim of $4 billion for Bank Malat of Iran, and I'm going to mention this in my address today. What I want to, message which I want to give today is that our Indian minds are the best in the world, but what we need is intellectual discipline, because we tend to go all the way around and not follow it. And I also believe that as a lawyer, you don't have to tell a lie, but you have to have a very creative mind. The first important thing as a lawyer is to always maintain a very, very high standard and integrity. And if you do that, even though you might face opposition, you will succeed. I'm going to today, I've today got it from a speech which I gave to the Law Society some 6 weeks ago, and I'm going to give an extract of it, and I'm going to refer to some of the Indian cases and how a lawyer can act. Some 3 years ago, Bank Malat, which is Iran's biggest private bank, they had challenged the UK government's listing under nuclear sanctions. Now, listing means that nobody can deal with them. And they had instructed a very big law firm, Stephenson Harvard, and they lost in the High Court and the Court of Appeal. And then they came to me for the Supreme Court, and everybody said there's no chance in the Supreme Court, you can't get a judgment against the UK government. And we did, we succeeded 5-4, and the Supreme Court said that the act of the UK government was both unlawful and irrational. And I'll just give you an example how the lawyers must show courage. Because one of the problems which we find with most lawyers that they want to also be popular with the judges and popular with the legal profession. Whereas I believe that so long as you have a clean heart, you have to stand up. When I was in Tehran, the chairman of the Bank Malat said, Britain is supposed to be beacon of justice, and there's a secret course, and we don't know what evidence is led against us. So I wrote a personal letter to the Chief Justice of UK Supreme Court, and everybody said, oh, you can't do that. But as a result, he adjourned the matter, and he brought it before 9 judges and not 6 judges, and we won. And today we have a claim of $4 billion in damages against the UK government, which is the largest ever claim in the UK court. And this is also the first time this has happened. Now, we must keep in mind that we are the only non-white firm in the city of, we are a multicultural, non-white firm, and people come to us from all over the world with difficult cases. When the Russian Federation lost a UKOS case just now, and there was an award of $50 billion against the Russian government from the Hague Tribunal, Hague Arbitration Tribunal, the whole team, all these big firms said, you can't do anything, this is an arbitration award, you have to pay. And they came to me, and we gave them a ground, which was a jurisdiction ground, which incidentally the same ground which we had taken for an Indian company, PEC. And they trusted me, so I said, you select a lawyer in Holland, because it was a Dutch court, it was a Dutch jurisdiction, and they won. And today the UKOS award has been set aside on the grounds of jurisdiction. Now, this is an example of what Indian can achieve in an international world. I'm going to discuss a few of the interesting cases where the lawyers can do. A few years ago, Indian Oil Corporation had an award against it for $18 million. And this would be of interest because they had agreed that the arbitration, in the 1979 Arbitration Act, parties can agree not to appeal or not to challenge the award, and they had agreed. But unusually, this is a very unusual case of what happens if the lawyer is incompetent. And Indian Oil had a very, very interesting situation because they lost the case, but Gordon Pollock, their arbitrator, QC, made a postscript in the award which said your legal team was incompetent. If you had a better team, you might better succeed. And this is a reported judgment. And in this award, Mr. Pollock said, I wish to record my regret that the seller had not at some stage broadened the scope of the case. The document gave rise to a strong indication that the buyers had intended to create a clear impression in the minds of the seller that if satisfactory settlement of the demurrage claim were made, nothing further would be heard of the enormous losses said to have been suffered by the buyer. In the result, I believe that the seller had a far stronger case than they allowed themselves to advance, one of which might well have succeeded had they been informed differently. Now, Indian Oil came to me and said, please do something. The whole team came, that if we had lost it was all right, but now with this comment by the arbitrator, our heads are going to roll. Everybody said you can't do anything, so you have to be creative. I took an opinion of a Queen's Counsel who said, sorry, this is an arbitration award. And then I made the application myself, but one has to be creative. And I said that we challenged the award on the ground that it would be against the English public policy, British public policy, to have the court enforce the award, because the award on the face of it was not the true determination based on a legal analysis of the evidence. It came up before the court and we succeeded. And the award was set aside by Mr. Justice Evans on the grounds that finality is a good thing, but justice is better. I'm going to discuss only one more Indian cases just now because the time is so short. And in the 90s, 80s, when I started, India was going through a food shortage. There were a lot of PL 480 wheat coming. And in the PL 480 scheme, India had to provide a vessel. And every vessel had a dispute because the charter party contained an arbitration clause. So there were about 150, 200 arbitration cases every year. And I was fortunate because when I started, I didn't know anybody in Delhi. But the High Commissioner, Mr. Syed Mahmud, was a lawyer, happened to be a barrister, non-practicing barrister, and he was quite bemused to see any not anglicized name, so he appointed me as a High Commission solicitor. And one of the first, we succeeded for the first time ever for India in the House of Lords. That was a case called La Pintada. And the issue was whether compound interest could be awarded for the late payment of debt. And in those days, because of foreign exchange crisis, India would always pay late for various reasons. So there would be huge compound interest liability. So the case came to me, the arbitrator has already made the award, and everybody said there was a Lord Denning's judgment in a techno-impacts case, if the debtor pays late, there's no need to have compound interest. And I couldn't find a barrister, because in those, now I can appear, but in those days a solicitor couldn't appear in court. So I instructed, Tony Blair was at that time a young barrister, was a contemporary of mine, and he used to come and sit in my office wanting shipping work, because we were the only sort of, except the big city firm. And he said, also instruct my senior, Derry Irwin, who later on became the Lord Chancellor. So I went to his, this is a true story, and I went to his chambers, and I persuaded him. I said, do you agree that this is right? Compound interest is wrong, because it makes the debtor an involuntary banker, which is not fair and not just. And they said yes, on the basis of which I took instructions from Delhi. And in those days, to get instructions from Delhi and for foreign exchange were not so easy as it is now. So they said yes. At 9 o'clock on the hearing, Tony Blair phones me up and says, please bring the legal representative of the Indian High Commission to the court. We want to talk. So we went at 10:30, and they said there is no case. It's going to spoil the Indian government's name if you take such a bad point. I said no. We are going to continue, and I advised my client, High Government of India, to sort of ignore the council's advice. We went into the court. Mr. Justice Totten was so well prepared, and he had done the research, and we succeeded. Matter was remitted back. Now, I'm saying this because a lawyer, we don't have to follow just the law. We have to develop the law. We have to be creative, keeping in mind that law is for justice and not justice for law. Matter went again to the same umpire, third arbitrator, and we lost again. And then the court gave us leave to go to the House of Lords, and I had instructed Nicholas Phillips, who later on became the Chief Justice of the new Supreme Court, and we won. But I'm going to give you the last example of a case of Food Corporation of India which created stir all over the world. It involved a very simple construction of a clause, entry at customs. Now in India, there's prior entry and a final entry, and Food Corporation said final entry is the right entry because the vessel is ready to discharge. And two judges, Mr. Justice Lloyd and Mr. Justice Bingham, had already said that the point which the Food Corporation of India, construction which they were going to put forward, was so bad, should have been twisted at birth. Then the case came to us, and this is the true story, so please listen. And I said, okay, I'll argue your point. In arbitration, I take the case myself. And it came up before a tribunal. And I said that this is a wrong construction. And the chairman of the tribunal got so angry with me, said that you have no right, you have no respect for the judiciary. And he became very abusive, and he walked out of the arbitration room. Now anybody else would have said, sorry. I said, no, but this is what I told him, that you have to listen to me first, and then you decide. Anyway, he went away. I said, let him go. A new third arbitrator was appointed, Michael Dean, and the same point was taken by me. And he explained to me that, we can't do this, but please put your point. And we lost, but he put my points very well. And the matter went to court before Mr. Justice Webster, and we won. So the insurance company brought the same claim again, another arbitration. Again, the same thing happened, we lost, and went before Mr. Justice Leggett, and we won. Then the other side appealed to a very large shipping firm, Maritime Law, Homan, Fennick and Willen, and it came up before Lord Justice Bingham for leave to appeal. And I said, my God, he's the same one at this point was so hopeless. And this is very important. And it came before him, so he said, let's have a half-a-day hearing. And surprise, surprise, he said, now this point, construction has put it differently. I think I was wrong in my earlier judgment. And this is surprising, but it only happens where the judges are totally independent. A few days later, Lord Wilberforce called me up, and Lord Wilberforce, as many of you would know, is considered a judge of the last century. And he said, is it true that Lord Justice Bingham in one of your cases said that I was wrong? I said, yes, sir. He said, can you send me the judgment? And a few days later, I got a letter which I cherish. He paid great tribute to Lord Justice Bingham and and myself for producing the victorious correct interpretation. Now, the example of this is that most lawyers today sort of say, oh, this is the law, this is the law. But they are not creative. And I believe that as long as you do your best with honesty and most important courtesy, never be rude and never be angry, and you can produce a lot of result. So with that, what I say is that India has a tremendous, Indians have tremendous ability. They have a very lateral thinking, and we must not allow ourselves to be looked down upon. The countries are today looking to the east. When I go to Iran and I meet the higher echelons, they say we are looking to the east. And we must now put our footprint in globalization comes to the low globalization in the world as Indian footprint without being shy, but with humility and confidence. Thank you.
I just would like to add one thing. When we landed last time in London, his name is being included in the top most 50 most influential person in London, Mr. Zaiwalla.
I'm sure that was a big mistake, and I was myself surprised when it came out that I've been included in the list of 100 most influential people in England. And I'm proud that I'm an Indian who has done that.
Thank you, Sarosh. I think it's a great learning exercise to be hearing from you, especially on how to prepare oneself for one's case. I think it will be a great treatise to the audience out here. Next, may I invite Honorable Law Secretary Shri Suresh Chandraji to kindly say a few words on this auspicious day. After this. A huge round of applause, please. And I must place on record that he has many pressing engagements, but he has kindly agreed to be here. Thank you so much, sir.
Respected Sarosh Zaiwalla ji, Shri Kaviraj Singh ji, Shri Ramaswamy ji, ladies and gentlemen, I am really impressed by the speech of Mr. Sarosh Zaiwalla, that Indians are they are intelligent, but only the thing is the discipline, intellectual discipline is required. And I fully agree with him. There is no today here we are celebrating the Constitution Day. This is an occasion to remember all the constitutional framers. I congratulate the organizers that they have chosen this day for their annual conference, and especially the topic law and policy. Though I have a written speech, I am motivated by Mr. Zaiwalla to speak extempore and say something which is really in my heart. So I'll not read my written speech. I'll restrict my talk only to what the government of India, especially my Ministry of Law, and especially the Department of Legal Affairs, which is basically a very small department, but it is the conscience keeper of the government. Various steps we have taken and the new government. But before I come on to that, I want to just discuss the legal ecosystem, especially our Indian legal system under which we work, and what are the strengths and challenges. Of course, our constitution has given a socialist pattern of society. It is a middle path, neither this way or that way. And we are bound. This is the outer limit. In this outer limit, sir, we have the Indian legal system, which has 4 components, basically. The basic values and virtues enshrined in the constitution, rights and obligations provided in the ordinary statutes, the organizational setup, and the organizational setup especially having the checks and balances, and the legal personnel. I don't know how many persons are the legal here, but I take the legal personnel are the judiciary, whole judicial officers, the legal advisors, the advocates, all those who are involved in the legal profession. It's a very big community. If we take, we cannot do much about the constitution and the basic structure of the constitution. That is the representative democracy. We will explain later. But one thing, the legal personnel, I belongs to the same fraternity, you also, most of you may be belonging to that fraternity. In India, what I feel, maybe, of course, again, it is not as law secretary I'm saying as an individual. See, there is some ad hocism, right from appointment of judges, appointment of arbitrators, appointment of the public prosecutors, appointment of the counsel, and especially the whole, I will say, even legal education. But all these are little bit, I will not go much, but there is a need for introspection in this field. Now coming to the challenges and keeping our law and policy in place to meet the challenges. The challenges are nowadays the scientific revolution in the field of information technology as well as in the means of transport has led tremendous, we were hearing Bill Gates last week. Few things, few concepts I would like to share. One of the concept was that henceforth, till now, men used to plan and the machines used to execute. Henceforth, the machines will plan and the human beings will implement. These are the new concepts. We have to think, and we have to think in terms so that our law, our legal framework, and our policy is in tune with this development. Then one concept came, what is called the physical world, digital and the physical. Now it is not the physical, it is the physical world. And frankly speaking, that reminded me the concept of ideas given by Plato. The Plato says, he gave a theory of ideas. The highest idea is the idea of God, and there are there is a hierarchy, and the lowest one ideas are the ideas of the non-living beings. And very beautiful thing which he has conceptualized is, suppose I am the Suresh Chandra. The exact replica of Mr. Suresh Chandra is in the heaven. That is the perfect idea. The idea which is perfect, that is infinite, that is non-destructible, and what here it is in the real world is finite, imperfect, incomplete, destructible. Now, if you come to the physical world, basically, again he has said whatever has been conceived by the God to make something as a perfect, but that individual thing never achieves that perfection. So there is a gap. Now here, if you see, we as a digital world, we develop and that works perfectly. When this is assigned to somebody, it is not so perfect. So now the physical world is coming, and somehow our most of the transactions which are made, whether the reservations, whether any online transactions, there are very least chances of mistakes. These are the perfect one. So now we are moving towards the physical world. Having said, when we talk of achieving the economy of a scale, then there are two things which are required. One, sir, is the ideology of the jurisdiction, that is the state. And second one is the transaction governance capacity. People call it in different form. Transaction capacity is the legal framework, the language, the communication skills, and the entering into contract, then enforcement, then resolution of disputes. All these things come in the transaction governance capacity. As far as ideology is concerned, we are the most open nation. As far as the language is concerned, nowadays our youngsters, over 600 million youngsters below 25 years, they are educated in 3 languages, sometimes the Hindi, then the regional, then some of the international languages. So I think there is no dearth of that. Then what is lacking? Where there is lacking? Lacking is somewhere there is a gap. The law which we have inherited, I was remembering yesterday I had a talk with Mr. Zaiwalla. He reminded me that 400 Englishmen, 4,000 Englishmen ruled 400 million Indians. That was the time, and I will say still they gave us railways, they gave us big India, that is called India, that they gave the concept of nationalism. Right from the Charter of 1833, very only one sentence, 2 sentences, the thing was perfect one, and nobody could have exceeded. Nowadays, in spite of INBA Delhi laws and all judicial pronouncements, if you see, everybody exceeds the limit, the power which has been given. So here is that aspect, the intellectual honesty, I will say. When we have so much of resources, when we have so much of manpower, topography, we have largest sea coast, natural resources like Himalayas and big land,
mines and all. Having all these things, if we can bring, or we can update our laws, and more important than laws, sir, I will say, because I am in the law ministry, I have seen we have lot of laws, but it is the implementation part. It is the implementation part which is missing, and sometimes there are duplication, there are all. So now coming to the whole governance part, before I come or I touch, I hope I am not taking much time, Kaviraj ji. Okay. See, the governance, because we come large, everybody, industrialist, a student, a farmer, professional, everybody looks towards the policies and the governance. So nowadays, I must say, under the leadership of our Honorable Prime Minister, the whole government, the whole all the secretaries, this is for the first time in the history of independent India, in 60 years. Everybody is sitting and introspecting about the functioning of the government. The results will come later on. I am telling you this thing. And in the governance, that the good governance, we are introspecting where we are going wrong. All top secretaries, all we as secretaries, we have lot of groups. I am in one of the groups, that is the good governance. Now, when we talk of governance, the government whole bureaucratic setup, there cannot be a government without a little bit steel framework of bureaucracy, that we have to admit. And at the same time, we have to see that they have certain powers, but at the same time, we have to provide checks and balances, that they do not exceed their brief. And perhaps this is by our task. I will say the Ministry of Law, whenever they provide certain standards in the form of laws, statutes, rules, bylaws, schemes, we take care of that. So, sir, what are the principles, the 4 principles, which are, I think you will agree with me. The principles are, the first principle is here, we always see backward. There is a conception, that is backward looking conception of legitimacy, from where we derive this power. Then, being a welfare society, we have to confer certain discretions, and the discretions have to be not unfettered. So, we provide rules, inflexible rules, and there must be a balance between the unreviewable discretion and inflexible rules. Then is the correction. Sometimes the correction is, first is detection. The detection of error, it can be at any time during course of implementation, sometimes during the course of audit and legal things. Within the government, it is the law ministry, some sort of acting like a Lokpal. Now, Meenakshi Lekhi ji is not here, so I will not highlight those issues which are likely to be. Otherwise, I was thinking that I will bring it into her notice. So, sir, the most important aspect is the detection of error and correction thereof. These are in place. We provide whenever we do our due diligence, whether in making the contract, whether making the rule, guidelines, schemes and all, we take care of that. And that is how the perfect standards, when are finally vetted or by prepared by the Ministry of Law, a very small, but still if you see most of the legislations, most of these things are are perfect one. That is another thing, that these are, you know, subjectively interpreted and implemented in a that manner. That's why there are the errors and there are litigations and litigations leading to uh, that enormous numbers, and that's why we are thinking of alternative dispute resolutions like arbitration, conciliation, mediation. Having said, now I will tell you what we are doing in the Department of Legal Affairs to address these issues, especially the contract enforcement or the doing business with ease. Last time we have amended the Arbitration and Conciliation Act with a view to bring three things, or rather four things. Number one, judicial intervention, which was at all the three stages we have tried to minimize. We have tried to bring an element of certainty in the fees. We have tried to fix the timelines, that is 12 months and extendable by another 6 months with the consent of the parties. And the arbitrators have to be above board. They have to make declarations that they don't have this. And some of the things, minor things like no automatic stay in the proceedings. Second important initiative which has been taken by my department is the enactment of commercial courts, commercial division, appellate division in the high courts. And these, I mean, once these are constituted and some infrastructure provided, this will go a long way in resolution of disputes and improving the India's rank in the world. And with these amendments, we have moved up by 13 points. Of course, in enforcement of contract, we have just moved only one rank above. Now we are at 172. In ease of doing business, we are at 130. Earlier we were at 143, then 131, and now at 130. Apart from that, we have developed one very important application for monitoring the cases. Here is the application of IT. So we have developed such an application that is already in place. Not only in it is being implemented, some new features are being developed to associate some certain other stakeholders like government councils and law officers. Then we are also making our department by having e-office. So once it is completely done, then it will be a paperless office. But I don't know how long it will take because there is a shortage of manpower and all. So with these things and our efforts being that wherever there is any power conferred, it should be bound, it should not be unfettered, it should be subscribed by certain rules, regulations and checks and balances. And with these efforts and other efforts we are taking, I will not discuss here because these are at a very incipient stage and these have very far-reaching consequences. But yes, we are trying and we are evolving a system whereby we have, or every authority has a competent legal advice available to him, and he should not take later on that plea that I was not knowing, or I was not legally trained, or there should be no escape for him from abdicating his responsibility. So we are trying to bring an accountability in the system, and we are trying to improve. And I was just saying that you have lot of topics wherein you will be discussing, and I hope and wish that this conference a success. With these words I conclude. Thank you.
Thank you, Suresh Chandraji. Extremely insightful, and I must say that you really shared the vision of the government, and very encouraging to know that digitization is not only the talk, it's actually the walk the talk. So very happy to note that, sir. And for the benefit of the audience, you will also be pleased to note that INBA is the first organization, and we are very proud to say that we are the first organization to be given the mandate to use the Make in India logo. So that shows that our efforts of nation building in terms of the social and legal arena is actually seeing the fruits of the day. So kudos to the entire INBA team and to the people for making it possible. Before we go on to the book launch, sir, I would like to do the customary honors of felicitating the members on the dais. So, Kaviraj ji, can you kindly do the honors, please? May we have the bouquet and the... Yeah. Kindly felicitate Mr. Sarosh Zaiwalla. May we have a round of applause, please? I believe everybody has had a good breakfast. Okay, Kaviraj ji, to Mr. Sarosh Zaiwalla, please. Thank you. I couldn't hear the claps. That's better. That's better. Now the important announcement of a book launch, as Kaviraj ji rightly said, we did a nationwide survey, the first of its ever kind, sexual harassment at workplace book we would like to inaugurate. May I also call on stage a couple of other people without whom this book launch would be incomplete. So may I request Sanjay Kaushik from Netrika, Jyoti Khetrapal. You have done an incredible job. Thank you very much. May I also call Dr. Khalid Manihar on stage, Ms. Andre Holikova, Mr. Rajat Tuli, Dr. Manoj Kumar, Zamir, kindly be on stage.
As we always say that we are not a just event organizer or a platform for a politics. We are inclined, or we are working towards to be a think tank and support and create a reports, research.
Maybe based on other events, what you would have seen, maybe you would see a bit of a disconnect because we are not professionals in this. We are all doing it out of heart. So kindly pardon us for that. I didn't want to miss the fun. Huge round of applause, please. We all will be getting this booklet. Tremendous energy has gone into it by the student workforce. So huge round of applause for the students. They went to each and every college. They did a questionnaire. They did a survey. Okay, I'm also coming. Thank you. This gives a complete, insightful image of the various surveys, the respondents, the quantum, the data size, and everything. And I'm sure it's a treasure book which you all will love to have. Over to you, Kaviraj.
As INBA, we are trying to bring a little bit change what we can bring. As our Honorable Law Secretary has said, yeah, please. Law is ever evolving and technology also evolving. So with
new technology, with new way of doing business, international. So law need to evolve very quickly and respond to the requirement of the present business. So we have also submitted the e-pharmacy report in association with the Sullivan, and on which Niti Aayog is inviting comments from the industry how to amend the drugs and cosmetic law. So we have done also submitted comments on cyber law, data privacy, as well as on real estate that has been already incorporated into the act. So I'm really grateful to the Ministry of Commerce to support our conference. Honorable Law Secretary, Mr. Zaiwalla, and our INBA team, and I would like to now, we are late, so we will start our main conference. Thank you very much.